Good evening. My name is Latrice Eggleston Williams, and I will be presenting to you explaining due diligence results and proposed solutions for our toy companies. Let me give you an overview. We will summarize, of course, the parties. We will talk about the issues of risk identified in the due diligence report, and we will discuss suggested changes and requests. And then we will consider some other items where we believe that this body will need to make some decisions and recommendations on. The summary of the parties is as follows. We are the buyer, Truly Green Toys Incorporated, and we are located in Marietta, Georgia. Our CEO is John Thoreau. The seller is Milk Jug Toys Incorporated. They are located in Vernon Hills and Chicago, Illinois, where their manufacturing offices are. They are a Delaware corporation. They are led by Lori Hillman, who is the Chief Executive Officer. One of their co-founders is Robert Graves, who no longer has stock associated in the company and is no longer a part of the company. The family members of Lori Hillman are board of director members, as well as some stockholders. Here are the issues that we found and identified from the due diligence report. Four specifically we will discuss and talk about, and that's the seller's authority, which we find in section 3.1. Do they actually have the right to execute such a transaction as this? In section 3.3, we discuss commercial agreements. And then in section 3.6, we discuss employment. As you know, the buyer would like to maintain the seller as an employee, and some additional employees will also be asked to stay on. But what liabilities does that really give the buyer? And we want to discuss that issue as well. And then, of course, the corporate structure in general. What is the power of the seller? Really, what is their authority, and how will that impact the board of directors and the shareholders, and what do we need from them? Here are the articles that are affected by our suggestions for the asset purchase agreement. We made some changes to Article 1, which provides definitions. We did some general edits. Any words that set forth, we struck those words and primarily put given, just to give more clarity for the language and to make it more simplified. We did, however, make some suggestions on some rewording of our definitions, particularly for contracts, for the data room, and for the disclosure schedules. For contracts, we wanted to make sure we incorporated all other agreements were included in this definition. And we wanted to make sure that they were legally binding, particularly for those written contracts, leases, mortgages, licenses, instruments, notes, commitments, and undertakings, indentures are all included. In terms of the data room, we wanted to make sure that it was established with the seller. And so we made some adjustments to that definition to mean the electronic documentation site established on the seller's behalf. By that contains the documents listed in the index in section 1 of the disclosure schedules. And then, of course, the disclosure schedules, which we wanted to ensure that it meant the disclosure schedules delivered concurrently with the execution and delivery of this agreement, the APA agreement, by the seller and the buyer. And then in Article 3, in closing, we have a couple more suggestions that we made. We, of course, inserted the seller's law firm as the location as to where the closing would occur. And then one of the deliverables that we did add was that such documents of consent and approval of asset acquisition transaction from the sellers, shareholders, and board of directors be also added to ensure that we covered any corporate structure issues, any issues related to the license and transfer of the IP assets, as well as, of course, making sure we ensure the seller's authority in executing this agreement. And then Article 4, reparations and warranties of the seller. We wanted to make sure we inserted Delaware and Illinois as a seller state of organization and doing business. In Article 7, conditions to closing section, section 7.05B, particularly conditions to obligations of all parties, we added and inserted board of directors and stockholders so that it would read, sellers shall have received all consents, authorization orders, and approvals from the government authorities, board of directors, and stockholders referred to in section 4.03. Now, here's just a summary of what some of those suggested changes were, and that was rephrasing of definitions in the article, contracts in particular, to make sure that it included all contracts associated with the acquisition of acquiring these assets. And then, of course, the verb tense, we wanted to make sure it was in the present tense, and we wanted to simplify some of the language associated with the agreement. Lastly, we wanted to make sure that we have proof of the stockholders and board of directors approvals and any other consents regarding the IP used of the vendors from the Green Gang LLC, where we would acquire the characters and toys that were being sold prior to, of course, the pre-closing. Other considerations were really wrapped around Article 4 in terms of representations and warranties of the seller. In particular, Section 4.02, authority of the seller. We suggested deleting the phrase similar laws affecting creditors' rights generally and by general principles of equity, regardless of whether enforcement is sought in the proceeding at law or in equity. And we wanted to present deleting that because it does limit the ability of the buyer to bring a breach of representation claim against the seller according to the asset purchase agreement, pro seller long form that we've reviewed. Lastly, of course, we want to make sure that all documents related to consents are placed in the data room and that it does not limit the ability of the buyer to indemnify any breaches associated with any of the warranties and representations held from the seller. And we wanted to make sure that we also address issues concerning the employee benefit matters, where we want to make sure that the seller remains accountable to employees who do not transfer to the buyer. But of course, we as the buyer in any merger or transaction that we would follow, of course, the federal, state, and local employment laws. We use the asset acquisition agreement, pro seller long form as a reference. We also use the toy manufacturer due diligence report, and of course, drafting contracts, how and why lawyers do what they do. If there are any questions, please feel free to contact me. I've given you my information, my email, and as well as my phone number.